Well, good afternoon, everyone, and welcome to our final panel in our symposium today. As Karen mentioned in her introduction earlier today, in 2003, Kathleen Folbigg was found guilty in the New South Wales Supreme Court for manslaughter of her baby son, Caleb, and for the murders of her other three children, Patrick, Sarah and Laura, all of them less than 18 months old when they died. Between 1989 and 1999. And all four children had died in their sleep and were found still warm by their mother. Her husband, Craig, believed Kathleen had killed them and testified against her in the trial. Now, there were two major types of evidence the prosecution used in its case. First, Folbigg had kept a diary, which the prosecution argued showed a mother confessing to having had violent feelings towards her children and admitting to having killed them. And second was the forensic evidence as to the causes of the children's deaths. Now, the children had all stopped breathing, that much was clear, but why they had stopped breathing was unexplained. And the potential options were either unknown but natural causes, or deliberate suffocation. And as we heard from Chris Milroy earlier on, suffocation doesn't leave any distinctive traces on the body. So the prosecution argued it was deliberate suffocation, and that was what the jury also agreed with. Folbigg was sentenced to 40 years imprisonment. The media described her as Australia's most dangerous woman, a monstrous mother, and someone who had committed infanticide again and again and again and again. Her appeals of the conviction, first to the New South Wales Court of Criminal Appeal and then to the High Court, were unsuccessful, and that exhausted the usual mechanisms available to a defendant to appeal their case. And in our panel this afternoon, we're going to talk about that 2003 case, but we're going to particularly concentrate on the extraordinary measures that Folbigg and her team pursued after those usual avenues of appeal had failed, and which ultimately led to her being pardoned in June 2023 after 20 years in jail. I'm Laura Dawes. I'm a historian of medicine and the law at the Australian National Centre for the Public Awareness of Science here at the ANU. And I'm interested in how science historically has been communicated to the law and how the law has used science. So I'm very keen to hear from our panellists their views on those particular aspects of the Folbigg case. After we've chatted for about 45 minutes, I'm going to open it up to you for your questions. My guests today are Dr. Jason Chin, Senior Lecturer at the ANU College of Law. And in his work, Jason looks at how research, and particularly science research, informs the legal system and its process. And he advocates for how that can be done better, including being a key voice in calling for changes in how research in forensic science is published. And Jason walks the walk as well as talks the talk on that one in his role as the inaugural Registered Reports Editor for Forensic Science International. And he's currently investigating memory reliability intoxicated witnesses as part of an ARC research collaboration. Definitely the one to volunteer for as a research participant there. And some of you may have attended Jason's workshop last year on rethinking science communication in the courts, which was where I met him and our second panellist this morning, Anna Maria Arabia, the Chief Executive of the Australian Academy of Science here in Canberra. Anna Maria started her career as a neuroscientist, before moving diagonally into the world of public service, politics and science policy. And she's been the CEO of Science and Technology Australia and Deputy Director at Questacon, the National Science and Technology Centre, which my own centre, CPAS, has had a long and very happy relationship with. Anna Maria has long been an advocate for science, its public awareness, and science for social justice. And it was under her leadership that the National Academy of Science played a key role in prompting further inquiry into the Folbigg convictions and ensuring the inquiry heard from appropriate experts. So that story to come. Welcome, both.
Thank you. Thanks for having us.
So let's start with that 2003 trial. Jason, I'll begin with you. Now, the forensic evidence didn't definitively show a cause of death for, 3 of the 4 children at any rate. Caleb and Sarah's deaths had been attributed to SIDS, sudden infant death syndrome. Laura's was similarly undetermined, but because she was 18 months old, that was kind of outside the period that SIDS is usually diagnosed for. And Patrick's was held to be a consequence of an epileptic disorder. Now, why were these not just 3 separate tragedies striking one family? What was the prosecution arguing there to connect them, essentially?
Right. So I think to answer that, I have to give a little bit more context. I'm not sure. I know this is this might have been covered already in the workshop so far, but did the Sally Clark case come up? No. Okay. So yeah, the kind of interesting context to this is that just prior to the trial of Kathleen Folbigg in 2003, someone named Sally Clark in the UK was acquitted of a murder that she had been convicted of and served about 2 years in jail. So her case was eventually appealed back up to the Court of Appeal there after the Criminal Review Commission in the UK looked at it. And so she had also been convicted of those 3 murders, of the murders of her children, just largely on the basis of it's really unlikely that so many tragedies would happen in the same family. And there was the sort of now infamous evidence. Some of you probably know about it. Roy Meadow, a English pediatrician who gave evidence in the trial. I'll just quote it. 1 sudden infant death in a family is a tragedy, 2 is suspicious, and 3 is murder unless proven otherwise, which we know is kind of fallacious statistical reasoning, but also kind of shifts the burden of proof to the defense, right, in a case like that. So one of the reasons that was appealed up to the Court of Appeal was a statement by the Royal Statistical Society in the UK, so kind of a precursor to what Anna Maria did, where they made a statement saying that there's no basis in like modern stats for this kind of claim. That was like in the mind of the court and the prosecution when when Kathleen Folbigg's case was. When the prosecutor chose to prosecute it, and then how that prosecution unfolded. And so the court made several decisions there. They sort of understood that it couldn't be solely based on the unlikelihood of the similar deaths in a family. But in this case, the reason it proceeded was, I think, because there was the diary in this case. I think
Let's talk about the diary
Sure.
sort of there. I mean, what has she written in it that seemed, so damning there?
And maybe I should keep my answer short. Sorry,
No.
It's hard to give context.
Got a whole hour.
Yeah. So the diaries, I think the diaries are fascinating. A lot of things that now, and I think to a lot of people, always looked like very equivocal statements. I think I have a quote from one of them at some point here. I can't find it. So things like, I really regret what happened. Next time I'm not going to let this happen again. Not saying that she did anything, but in the context of everything that people knew about the case. And
Sarah left with a bit of help was one that was routinely.
Absolutely. And so on appeal, I'm skipping ahead to the first appeal. So the appeal in 2005 about whether the jury conviction was, that the jury's decision was reasonable or unreasonable. So we don't know what the jury thought because it's a black box, but we know what the appeals judges thought. And one of them said that that entry was chilling in light of the known history of Caleb, Patrick, Sarah, and Laura. And assuming they were authentic, which was not disputed, the probative value was damning. So a judge at the Court of Appeal just said, this like in light of what we know, this diary entry is damning. The quite interesting thing is, as this went on, later at the final, I'm really skipping ahead, but later at the final inquiry, Justice Bathurst, former Justice Bathurst, said that it's not an admission at all. It's equivocal.
Let's not reveal the ending. Let's not reveal the ending. We have to get there first of all. So we've got these sort of multiple deaths of SIDS in a family, and a current understanding, well, maybe within the medical profession, that if one child in the family dies of SIDS, this doesn't mean that there's a higher risk for other children in the family also dying of SIDS. So when you get a string of 4 children all dying of really quite, fairly rare sort of thing, reverting to Meadows' law, that sort of suggests, murder, because that's just, the multiplication of 4 very rare probabilities is infinitesimally tiny. And then we have this sort of diary being, interpreted as essentially a confession. Anna Maria, what other interpretations were available of the diary, and did the court really explore those other possible interpretations fully?
No, not at all.
Yeah.
In fact, in the 2019 inquiry, which was the first inquiry into her convictions, Reginald Blanche was overseeing that, and he is on the record saying words to the effect that he didn't need a psychiatrist or a psychologist or anyone to provide him with an interpretation of the words in the diary. And remembering there are around 40,000 words written by Kathleen Folbigg over many years, and what was cherry-picked were those that were misinterpreted and most damning. And he said that as a layperson, he could read those words and understand what they mean. Now, this is someone overseeing a judicial inquiry, disregarding, not even allowing experts to come in and interpret those diaries. It wasn't challenged that I'm aware of. They were taken at face value. There was no consideration given to any postpartum depression that Kathleen Folbigg may have been experiencing. No consideration given to the circumstances around the trauma associated with 4 deaths in a family, let alone the conviction and beyond. She wrote, and no consideration given to methodologies and interpretation of journaling. And most people in journaling are encouraged actually to write down everything, just to kind of get it out on paper. So that sort of context wasn't explored, and those very much cherry-picked words, which were amplified by the media, were seen as admissions of guilt. And circumstantial evidence in that case really was given greater weight to any scientific or medical evidence. Something I do need to say is that there was an explainable cause of death of all of the children really early in the piece. So SIDS was 2 of them. There were signs of myocarditis in Laura, so her heart muscle was inflamed. It was reported by pathologists but disregarded. And Caleb Patrick, oh goodness, I can't believe I'm even using this.
Patrick, the epilepsy?
Who had epilepsy and a floppy larynx. He effectively couldn't breathe and swallow at the same time. So he died very, very young. So individually you could have explained them on medical terms. And indeed there was no light cast on the family until after the 4th child, and a police officer said, this is odd, what's the chances? What are the chances? And that misuse of statistics, which you spoke about, Jason, really came to the fore, where there was a calculation made that it was so unlikely, when actually, when we now know of the genetic mutations that at least 2 of the children had, it's actually not so unlikely at all. But so I strayed from your question around the diaries. But there was no expert there to interpret the diaries, or even allowed to be.
He was kind of reading them as if it was, like a piece of legislation, and you just read it with the plain meaning, and
That's right.
It was not that.
And said as much.
Yeah. So Kathleen Folbigg was found guilty, 2003. None of the appeals extending through to 2007 were successful. But during and after that time, geneticists had been doing some interesting work. And in particular, the 2 genes for carmodulin had been identified in 1987, a third in the 1990s, and then investigations in the 2010s started to unravel what that particular substance sort of did in the body. So Anna Maria, give us a tutorial here. What is calmodulin and what does it do in the human body?
In very, very broad
Yes,
terms,
broad terms,
there are 3 calmodulin genes. Calmodulin 2 is the mutation that Kathleen Folbigg herself and her 2 daughters carried. They carried. And it is a highly preserved gene. What that means is it is really unusual that you have a mutation in this gene, and it's considered the idea of having the 3 genes is some redundancy, because if you do have a mutation in a gene, it can be lethal. And indeed, it was in the 2 girls. There is also this concept of variable expressivity, which means it's not lethal in everybody. So Kathleen's alive, and in fact, one of the some of the reasoning used against her was, you're here, you're alive, and you know, why aren't you dead if you've got this mutation as well? When we know that it is not only expressed differently across people, it's expressed differently across organs. And indeed, one of the real issues that's not been explored is that she was never given any access to cardiological treatment or investigation while she was in prison,
Because
knowing that she could have
in the human body.
Absolutely, she had some fainting episodes. She had particular reactions to circumstances in jail. If she were out of jail as a free woman, she would be seen by a cardiologist regularly.
Yeah, because calmodulin is involved in heart function,
That's
right?
right.
In the
So
heartbeat,
immediate stopping of the heart, cardiac arrhythmias, and the myocarditis that we saw with Laura is very typical of that presentation as well.
Yeah.
In fact, there is an international calmodulin registry, calmodulopathy registry, which are those people who have mutations in any of the 3 calmodulin genes. I think there are around 180 people on that registry now. And indeed, at the time of this first inquiry, there was another family in Macedonia where the children had died, and another one where a child had collapsed but was saved with those mutations. So whilst it was very rare, there had been expressions of it. So highly preserved that it is quite rare to see that change, and when it does happen, it can have lethal consequences like the stopping of the heart.
Yeah. So by 2012, 2013, there'd been sort of some studies into what effects calmodulin and its mutations have in the body. Of course, Kathleen Folbigg had already been in jail for 10 years by that point. But in 2015, the Governor of New South Wales received a petition from University of Newcastle Legal Centre on behalf of Kathleen Folbigg, asking them to institute an inquiry, the 2019 inquiry that we've been talking about. Jason, what in particular prompted this petition?
Well, I think, from my knowledge, so another thing to note is that in 2011, so I think Kathleen Folbigg's supporters, her friends, and one friend in particular, and some other supporters, and the group at Newcastle sort of never really kind of lost faith, and they were always kind of in the background. I suppose one reason behind the petition is they had run out of appeals and through formal processes. The other thing I would note is that in 2011, Emma Cunliffe's book came out. Some of you would know of her. She's an Australian-Canadian legal scholar who, before any of the new genetic evidence came out, just wrote a book pretty much dissecting piece by piece the evidence, and came to the conclusion, as some people in the legal academia are kind of wary to actually give opinions on the facts of cases, but she came down squarely that she was more likely innocent or not convinced beyond a reasonable doubt. So there was Emma's book. There was they run up appeals. One other thing I would note is that there was another possible appeal point. So this comes out sometimes, but one of the jurors had looked up Kathleen's family and found out that her husband had killed her mother. Her father had killed her mother, and told that to other jurors, and it got out and was never sort of cross-examined or never became something that the defense could make submissions about. And there was an appeal on that, I think in 2009 or so, and that one also the Court of Appeals said, that's true, but we're not convinced that this would have affected the jury's decision. How do you know? I've lost track of your question at this point.
Yeah, no, that's good. And that discovery that by the jury that the father had murdered Kathleen Folbigg's mother, gave a certain light on one of the things that Kathleen had written in her diary, where she said, "I am my father's daughter," and if you know that the father was a murderer, maybe that phrase could be interpreted in certain sort of ways. But yeah, so, and you mentioned that the lines of appeal had been sort of exhausted. How is the inquiry going to be different to appeals?
Well, the hope was that it's a less formally adversarial procedure, and I guess that actually did work out. I don't want to again skip ahead, but the fact that the second one was a less formally adversarial procedure did allow for, I think, the evidence to be heard a bit better. But I guess the idea is that you're not constrained by the adversarial structure, so you can call a wider range of evidence. You can examine them. The judge examines them, and the judge can play a better role in examining them. I know there is some sort of quasi-adversarial things happening. There's counsel assisting. But yeah, so just a less structured approach. So I guess more similar to how you would do it in an inquisitorial jurisdiction.
Mm-hmm. Now, so the inquiry did hear evidence as to possible genetic common sort of causes for the children's deaths. And in fact, two different teams of geneticists were engaged by the inquiry to look into this. There was a Sydney-based team and there was a Canberra-based team of Professor Carola Vinuesa and Professor Matthew Cook, both here at the ANU. And both of those teams, Sydney and Canberra, found that Kathleen and her children shared certain genetic patterns, and in particular, as Anna Maria has mentioned, that Kathleen and her two daughters shared the same variant of that carmodulin CARM2 gene. Now, the Sydney team felt that that particular genetic variant was not sufficient to have led to the children's deaths, while Professor Vinuesa's team thought that that CARM2 variant would have been very, very serious. So two different sort of slightly different interpretations there. Now, Anna Maria, did the 2019 inquiry hear everything it needed to hear from the genetic research?
It may have heard it, but they certainly weren't listening. Carola Vinuesa did put forward her interpretation of the genetic mutations. And actually, this is a classic example of differences between clinical practice and experimental research. So those geneticists who practice in the clinic, and they were part of the Sydney team, looked at this genetic mutation, and it didn't fit into certain classifications that are used within the clinics to classify children, or anyone really, to determine what lines of treatment they might need. And you can imagine that clinical practice and the way that's determined is based on pre-existing evidence, as it should be. If I had a stroke, I would want the best possible evidence-based treatment based on all of those before me. But in a novel mutation, the way you treat that, or the way you classify that, or the severity or implications of that mutation are never going to be in clinical guidelines because they are too rare. Indeed, it just won't get there. And yet, if you're a clinician seeing patients, you'll say, this is rare, it could be. The likelihood of this mutation leading to their deaths might be 70%, whereas Carola Vinuesa looked at it from a scientific perspective as somebody whose bread and butter every day is to look at genetic mutations, try and understand them, try and understand the mechanisms behind them. And she was in no way convinced that this was unlikely or less likely to be pathogenic or lethal. And so she put that case, and the commissioner at the time said that he preferred, and I've been told that that's a legal construct or language that's often used in courts, but from a scientific perspective, we don't prefer evidence. There's evidence, and it meets a threshold and a standard of rigorous analysis or not. Anyway, he preferred the Sydney team's conclusions, and so Carola's evidence was disregarded. She, I'm not sure if anyone has ever met Carola Vinuesa. She's a force of nature. I'm yet to be, there's nothing she's ever put to me that I can push against. She's just the most persuasive, extraordinarily forensic, rigorous, integral scientist you'll ever meet. And
So
she couldn't rest. She felt very uncomfortable with his conclusion.
But that 2019 inquiry essentially upheld the original trial's verdict, but perhaps hadn't really quite grappled with, what had been sort of discovered in this genetic evidence. Now, we are at the point when the Australian Academy of Science became involved. For those of us who don't work in the sciences, tell us, what is the Academy of Science? What do you do?
Thank you. We, as our core mission, provide evidence to inform decisions wherever those decisions are made. And typically people think about the Australian Academy of Science and learned academies across the world as providing evidence and science to decision makers, usually ministers. That's often the audience that is associated with learned academies, but in fact decisions are made everywhere. They're being made in this room right now, they're made in the public square, they're made in courtrooms, they're made in classrooms, in boardrooms. And we increasingly seek to provide scientific evidence in a way that is accessible and synthesised to those decision makers, wherever those decision makers might be. This was the first time we had played a formal role in a legal inquiry. It's not the first time that the Academy had spoken about the scientific veracity or lack of in a court setting or in a procedural setting. So the last time that happened was the Lindy Chamberlain case, when Ian Fraser and I think it was with Peter Doherty, or was it Gus Nossel? Anyway, some of our fellows had written to the authorities at the time to question the scientific integrity of the evidence that was used to convict Lindy Chamberlain. And it was never to the extent that we became involved in the Folbigg case, but there was some history of our involvement in those matters. And separately, for many years, we have been looking at matters at the intersection of science and the law.
So how was it that the Australian Academy of Science became involved? Was it via Professor Van Weser?
It was. So she was really quite frustrated by the way science had not been explored or thoroughly explored in that inquiry in 2019. And shortly after the inquiry, she had found more evidence in favour of that calmodular mutation being pathogenic. And she wrote to the courts and said there is additional evidence, and they had not produced their final report, but they didn't incorporate that additional evidence. So she felt very, very uncomfortable and came to the Academy as an institution with authority and gravitas and said, can you do anything to help? We need assistance here. And, I'll be honest, when she first approached me, I said, are you sure you've got this right? This woman's been in jail for several years, and isn't there more to this? Can't just be this calmodular mutation. And we were rightly sceptical, as scientists should be. And the more I read and the more she was able to walk me through the evidence and her personal treatment. Carola was heavily discriminated against during that inquiry. Her scientific credentials were questioned because of her ethnicity, where she was born, where she trained. It was really quite extraordinary. That riled her and me. So, we took a closer look, and Professor John Shine was the president at the time, himself an immunologist at the Garvan Institute, where there is a lot of genetic work done, and he looked at the evidence and felt, something's not right here. So
what did you do? What happened next? Yeah.
Carola continued to gather scientific evidence to try and understand if this calmodular mutation could have been, or the likelihood of it being pathogenic in the two girls. And so she used her international network, and over that time was able to bring together 27 experts from around the world, from 7 different countries, each with their own technical and scientific expertise. Some people had done functional analysis studies, others had looked at the implications of that genetic mutation from other aspects. And they published a really seminal paper, often referred to as a Brovis paper, and that was published in March 2020. And it was on the back of that paper that a petition was started, and that petition sought a mercy plea to the New South Wales Governor to give mercy to Kathleen Folbigg and free her.
And who's on this petition? Who signed it?
90 of many of the Fellows of the Academy, Nobel laureates, are really some of the most distinguished scientists in Australia. And it was they looked at the evidence, they looked at the published evidence, and for them there was no doubt. It was very clear that this case needed to be reinvestigated or she needed to be pardoned. And so that was submitted to the Governor of New South Wales, and the process there, as you know, is that the Governor seeks advice from the Attorney-General. The Attorney-General took 1 year to prepare that advice, and the advice back to the Governor-General was to call a second inquiry, which he did very reluctantly, and he said as much in the meeting.
So, if you're keeping count, inquiry number 2, which, is not one of the standard appeal processes. So these are extremely extraordinary measures prompted by a petition having, sort of nearly 100 signatories of Australians, scientific sort of luminaries on there. So we've got the new genetic evidence, but let's go back to the diary evidence though.
Could I add something?
Yeah, sure.
There were 90 people on that initial petition, and there were 165 New South Wales-based scientists who wanted to be, but it had been submitted, so they started another one. So there was
petitions going everywhere, inquiries going everywhere,
snowballing support. So it was in the hundreds. Really.
Yeah, wow.
The formal petition had about, I think, 96 or something, but yes, there were many other supporters.
There were more than just what was submitted in that. Yeah, right. So the diary evidence. We're going to talk about the diary evidence. So you recall that had been interpreted at the trial as a confession, basically. Jason, how did this now second inquiry reevaluate that diary evidence? What did they do now?
Well, Anna Maria mentioned this a little bit, but I think the second inquirer was more willing to hear evidence from psychologists and psychiatrists about what other possible reasons someone could have for using words like these. So they weren't allowed to go as far as to say, my opinion is that this is an admission or a confession or not, but they would give a bit more context to that. And that might have been important. My kind of personal, or one of my theories is that, the next inquirer was also evaluating the diaries in light of the DNA evidence. So he kind of knew that the scientific case was not as strong as previous people thought it was, and that there was strong exculpatory evidence. And so he's reading those diaries from a very different perspective. And
I think credit needs to be given to Commissioner Bathurst. He could have in a very focused way, concentrated on the genetic evidence alone, and he chose not to, and he was encouraged not to by Kathleen Folbigg's legal representatives as well, who presented information that I think he looked at and thought, I should do this comprehensively or we're going to be here again for a third inquiry at some point. And so he did take the liberty, I think, of being quite comprehensive in his assessment of all of the evidence, not just the genetic evidence. And he was very clear that he wasn't going to take as given the outcomes of the 2019 inquiry. He was going to look at that very neutrally and draw his own conclusions. That's gutsy, I think. But he went through that in a really rigorous way. The Australian Academy of Science then did something that, as a scientist, I didn't know all the legal processes. I've had a very steep learning curve in the last 4 years, but we sought to be legally represented at that inquiry. And we received pro bono assistance from a legal firm here in Canberra and Sydney, we sought legal representation and it was granted. So that's another thing that I think I give credit to Commissioner Bathurst for. He could have said, thanks, we'll come to you if we need you, but, a legal representation might be too far, and he didn't. And I think that was his way of saying, I want this to be clear and comprehensive, and to have before us all of the information so we can make an informed decision. And if it turns out that she's still guilty, or we believe there's no reasonable doubt, well, so be it. We will have at least been able to say that we did this comprehensively.
And what did the Academy do during the inquiry? I mean, we've heard that, sort of the Academy's petition was one of the mechanisms for prompting it. But, in being, legally representative in the inquiry, what did that allow the Academy to do?
So we were granted leave to provide recommendations on the best possible experts to give evidence in particular scientific matters, to clarify scientific matters as needed, and to ensure that the questions put to those expert witnesses were appropriate. And the reason that that's important is that in that first 2019 inquiry, there were various questions put to the scientific and medical experts that were out of their field. So I'll give one example. The Sydney team were asked about, have you ever seen a case of calmodulin mutation such as this, where someone has died in their sleep, so not under exertion and under the age of 2? And they said no. And there were many questions put to them and they said no. Now, they weren't lying. They had no understanding or knowledge of the International Calmodulin Register, which actually held that evidence. So they were effectively asked questions outside of their domain, and they were the wrong experts to be asked certain questions. So our role in the second inquiry was to ensure there was alignment between best expert and most appropriate questions. We worked mostly behind the scenes. We were not given permission to cross-examine. I was pleased in the end that that was the case. I don't think that was our role. We were able to be an independent scientific advisor, and we were able for every witness, including Carola Binweiser, to say, hey, counsel assisting, this witness has got a gap in their evidence here. Here's some scientific questions you might wish to consider in your interrogation of them to clarify that. And I think, I believe that assisted counsel assisting to get what was very, to sort through the grey, and there's always grey in science, and to reach consensus across all expert witnesses, those who were arguing the likelihood of the pathogenicity of a calmodulin mutation being very likely right through to those being unlikely. So counsel assisting was able to question them in such a way as to gain consensus across all of them where they all did agree, and that was the information that Bathurst was able to use to determine his views on the genetic side of this. However, it was really his willingness to then hear from psychologists, psychiatrists, which we also provided recommendations for, that enabled him to investigate all of the different strands of evidence that were used to convict her, and then ultimately led to his conclusion of reasonable doubt as to her conviction. So it wasn't just the science. The science was a trigger to get there, but then the investigation of all of the evidence enabled that. Yeah. And it was comprehensive investigation, and that's to be commended. I wish it's a one-off that I'm aware of. I've not seen it happen before, and I don't know how we make it happen at scale, but it needs to happen at scale.
Jason, your thoughts on this?
Yeah, just to emphasize something that's probably obvious is that in a normal, this was an inquiry in a criminal proceeding in most countries. A learned academy can't have legal representation, and they're not so widely involved. So
yet.
So somewhat of this is a data point suggesting that maybe the normal way in which science is presented in courts doesn't work very well because of those adversarial restrictions.
Well, yeah, I have a question about that as well. In the US in the 1970s, there was an idea kicking around for a thing they were calling science court. And this was going to be a specialist tribunal that would look at new and developing science before it was presented as evidence in a trial. And how science court was going to work was it was going to be different from a trial court. It wasn't going to be adversarial, it was going to be inquisitorial. And the court itself was going to call experts to help advise it and help it understand these sorts of things. So do you think a process like this, science court, would be useful in our system? What do you think, Jason?
Well, it couldn't be much worse than how it's currently done. So yes, I guess. And other areas of government work this way. So some regulatory bodies have scientists on them, so that can work, I think. I mean, questions would arise about who picks these people, like how they're appointed, how transparent is that system, and there's evidence from my other field of psychology that people, one key component of the procedural fairness or procedural justice that people experience is being able to choose their own kind of advocates and witnesses. So would challenge some of that stuff. But currently the way it's done doesn't work because usually it's only the prosecution that has an expert witness. The defense can't afford their own.
Yeah.
So, and it's someone who's chosen by the prosecution with a particular view from a particular discipline. So I think it would work better than that.
Science is adversarial, the way it gets presented, yeah. So, Anna Maria, I mean, you've mentioned that, the Australian Academy of Science acting as this independent scientific advisor to the court was just incredibly unusual. Do you see a potential ongoing role for the Academy doing that? And if so, how's that going?
If resourced, yes. But look, to be honest, I'd like to see that role performed by someone. And that could be the Academy of Science. But I think an independent body, whatever that body looks like, that's able to bring multidisciplinary expertise to inform decisions within the justice system would be a significant step forward in the way that system works and the reliability of that system and the way it delivers justice. It could be the Academy. We actually weren't involved in any way to kind of lobby for an extra role of the Academy. It was more of a demonstration case, to be honest. What we are doing is, from our experience in the Kathleen Folbigg case, we are trying to pursue some law reform that would see the creation of a more science-sensitive legal system. And we're talking about, a case here in the criminal system that was a wrongful conviction. But I want you to think about this more broadly in terms of how courts are and will be increasingly challenged by cybersecurity, technology and crime, by AI, by quantum computing, when encryption codes are broken and our banking system collapses and cloud computing ceases to exist. There's going to be legal proceedings, litigation that we're already seeing around climate change. I mean, it isn't new in so much as I remember during my PhD studies, the cardiologist I was working with said to me, I keep getting called to give evidence around how stress causes heart attacks or not. And there is some evidence, and now that's well advanced. So this has always been a evolving science, but I think the pace of technological change, the complexity of it, the disciplinary knowledge that's needed across some of those things I've just described between climate change, cryptography, AI, high-performance computing is at another scale. And I think it is unfair to expect a justice system or any legal system to be able to keep abreast of that and for jurors to be able to understand the context of that information that's presented to them. So we do need to find mechanisms to enable the system to be more scientifically literate. We are trying to speak to attorneys across the country, including the Federal Attorney General, with variable success, I think is the best way to describe that. But it's ongoing. The doors haven't closed.
One of the dilemmas, of course, is that, science is a historical process. And we've heard that, the identification of the clinical effects of these comodular variants was really only understood sort of a decade after Folbigg had been convicted. But of course the law had to make a decision. Do you feel that the law adequately gets the idea that science changes? And could it do better at responding to the fact that science is evolving all the time? What do you think?
I think they do get it, and we get that they need to make decisions. You can't walk into a court of law and say, oh, wait a minute, I need a couple more years in ARC grant to do.
Hang on a second.
We'll come back to you on that in a few more
Yeah.
research required. As you can't walk into a minister's office and say, I know you need to make a decision about what we do with SARS-CoV-2 transmission in Australia, but we haven't quite understood that. So, I think what's important in that context is to communicate uncertainty. And we don't see good communication of uncertainty in forensic evidence, for example, but in a range of forms of evidence that's before the courts. We do appreciate that they need to make a decision. And sometimes that decision will be incorrect, not at the time, but will come to be understood to be incorrect. What's important at that point is that there are mechanisms to enable the reinvestigation of some of those cases. Now, it can't be every case. You can't leave every case. Imagine every convicted criminal saying, but there's still a chance and there is infinite number of appeals. But one of the things that Jason and I have been speaking about is this concept of a post-appeals review mechanism like a criminal case review commission that exists in other countries, where when a certain threshold is met, so it's not any old evidence or anyone deciding that you should reopen a case, but when a threshold is met, there would be an opportunity or mechanism for the reinvestigation of that case and new evidence to come to light. That won't happen all the time. I mean, it will happen because we are human and humans make decisions, including in our courts. And so there will be errors and there will also be new information that was not available previously.
But a mechanism that doesn't
That
involve
enables
getting Australia's Nobel Prize winners to the governor. Yeah.
Kathleen Folbigg had a team around her that if you had to pay them, no one would have access to. And there is an inequity there, I think, in that injustice as well.
Mm-hmm. I'm somewhat struck by the parallels, particularly with the Chamberlain case, which of course always looms large over any case involving infanticide in Australia. In particular, Anne-Marie, you mentioned scientific witnesses being asked to give an opinion beyond their area of expertise, and that of course was one of the conclusions of the Royal Commission into the Chamberlain case, that experts in that case had been asked to opine on things which they were not expert on. One example was having a UK expert on dogs giving an opinion on dingoes, sort of beyond the limits of his expertise. But I'm particularly thinking of the diary evidence here, and how that was interpreted in the Folbigg case, and how Lindy Chamberlain's behaviour publicly was interpreted, especially by the media. I mean, do you feel that women are being convicted on the basis of assumptions about the right way for mothers to grieve their dead children? Jason, what do you think?
Yeah, so we've been talking about what was technically in evidence, like before the court, but there were all these sort of latent stereotypes and myths about how people are meant to behave in certain situations that the jurors as humans are going to have, and it's never fully articulated. You can't cross-examine that. It's just things that they think. And the same with the few jurors who knew about her father, right? This was never the subject of evidence and submission. So based on what we know about humans, it surely plays a role.
These days we'd say it creates a vibe, wouldn't we? We'd say that it's a bias or a subconscious kind of context within which you would view evidence, whether you were doing that formally in a trial or appeals process, or in the public court in the public generally. So one of the things that has been really interesting is to listen to, there was a public relations, a media company who assisted in Kathleen's, in the media around, in the lead up to that second inquiry and beyond. And they speak about having had a strategic objective to change the public's view of Kathleen from this murderous, terrible person who must have been guilty to maybe she's not.
Yes.
And to have some of that momentum build, because that was important in media reporting, which therefore impacts perhaps someone sitting in a courtroom, even though it's not in evidence formally.
And we actually experienced some of that in preparing for the symposium today, because we were looking into using a photo of Kathleen Folbigg for our poster, and we're not able to do that because we were calling it the lethal maternal. Well, on that, where we finish up with a woot for science communication and the public awareness of science, please would you thank our panel guests.